A federal judge just refused to let a major concealed carry delay case die. And if your local agency thinks it can stall your permit for months or even years, that should make you sit up right now. Pause. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could keep you from making a huge mistake with your rights, your paperwork, and your timeline. Hit that button now. Here's what just happened. A federal judge in California said a lawsuit against the Los Angeles County Sheriff's Department can keep moving forward. That matters because this case is not about some tiny paperwork glitch. It is about whether a government office can drag its feet so long that your right becomes meaningless by the time they finally answer. And let's be honest, that is how a lot of these systems work in real life. They do not always say no. Sometimes they just make you wait so long that you give up. Let me break that down in simple English. The Sheriff's Department tried to get the case tossed out early. That kind of move is called a motion to dismiss. All that means is they were telling the judge, this case should end now before we ever get to the full fight. But the judge said no, at least on the core delay issue. She said the individual applicants and the gun rights groups had enough of a real injury to keep suing over the long permit delays. Some of those delays were alleged to last up to 2 years. Now, this is where it gets interesting. This was not the first warning shot in that case. Earlier, the same federal court had already signaled that the law and the facts looked strongly in favor of 2 applicants who dealt with roughly 18-month delays. Think about that. 18 months, not 18 days, not even a bad 90-day delay. A year and a half. For a right, the Supreme Court has already said belongs to ordinary law-abiding citizens. Have you ever wondered how a right gets blocked without being openly banned? This is how. A state or city says, sure, you can apply. They hand you forms. They take your money. They make you do the training. They make you book an interview. And the clock just keeps running. Weeks turn into months. Months turn into a year. You call and nobody answers. You email and you get silence. You start thinking maybe you forgot something. Maybe you made a mistake. Maybe this is normal. And that is exactly the trap. Here's the part most people get wrong. They think a delay is just annoying. They think it is like waiting on a passport or a driver's license renewal. But a delay on a carry permit can work like a denial if it stretches far enough. If the process takes so long that you cannot exercise the right in any practical way, the delay becomes the punishment, and the court appears willing to take that argument seriously. Imagine this hypothetical example to explain this. Say you live in a high-crime area. You work late. You walk to your car after dark. You apply because you want lawful protection. You do every step they ask for. Then they schedule your interview next year. Then they ask for more documents. Then they push the review back again. By the time they finally act, your job may have changed, your danger may have changed, or you may have already spent thousands trying to force movement. That does not feel like a right. That feels like a maze. But wait, there's something even more important. This ruling does not mean every permit office in America has to approve everybody tomorrow. It does not mean permits are gone. It does not mean there is one giant national order ending all gun licensing. Do not make that mistake. What it does mean is this. Courts are showing a growing willingness to look at extreme delay tactics and ask whether they cross the constitutional line. And if you live in a place where the agency always says, we're backed up, you should be paying very close attention. Backlog is not some magic word that erases rights. Staffing problems are real. High application volume is real. But there comes a point where we're busy starts sounding a lot like we don't want to. Pause. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when police ask about your gun. Subscribe so you don't miss it. Now let's talk about the move that took this story from local problem to national warning sign. The Department of Justice did not just issue a press statement and walk away. It opened an investigation into Los Angeles County over these permit delays. Then it filed what it described as its first affirmative lawsuit in support of gun owners. That is a big deal no matter where you stand politically, because the federal government is saying delay itself can be a civil rights problem. According to the DOJ, it looked at data and documents covering more than 8,000 concealed carry permit applications. And what it said it found was shocking. The department said the sheriff's office had only 2 approvals in that massive batch of applications it reviewed, and some interviews were being scheduled as far as 2 years after the completed application came in. When I found that out, I couldn't believe it. 2 approvals out of more than 8,000 reviewed applications is not just slow. That looks like a system barely moving at all. Here's why that matters for you. The DOJ is not claiming that every denied application is illegal. It is saying the pattern of delay can itself violate the Second Amendment when law-abiding people are kept waiting far beyond the legal time frame. California law already has deadlines on paper, but paper deadlines mean nothing if nobody enforces them. And this is the part nobody's talking about enough. The federal government even set up a contact point telling people to reach out if they had applied in Los Angeles or in any jurisdiction in the United States and had not received a reply or decision within 4 months. Read that again in plain English. The message was not just, we're watching LA. The message was, if this is happening to you somewhere else too, we want to hear about it. That should tell you the bigger fight is not really about one county. It is about a growing argument that states and cities cannot use bureaucracy as a backdoor weapon against carry rights. Most people think gun cases are always about bans, magazine limits, or so-called sensitive places. But sometimes the biggest fight is more basic than that. Can the government take your application, take your fee, and then trap you in limbo? First thing, watch the clock. If your state law says the agency must act within a certain number of days, know that number. Second, document everything. Keep copies of your application, receipts, emails, training records, and every date you were told to wait. Third, do not assume silence means your file is being handled correctly. Silence can be part of the problem. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Here's a hypothetical example to explain this. Let's say you applied 9 months ago. Your state says the agency should decide in 90 or 120 days. You have called 3 times. You have emails saved. Nobody has denied you, but nobody has approved you either. A lot of people in that spot think, well, I guess I just keep waiting. But if courts and the DOJ keep moving in the direction they are moving now, that kind of delay may become much harder for agencies to defend. But here's the crazy part. This may not stop with Los Angeles. DOJ officials have already said they want more action on gun rights enforcement, including permit delays and extreme costs. In other words, they are not describing this as a one-off California story. They are describing it as a broader civil rights issue. And once the federal government starts saying a practice may be unconstitutional in one place, agencies in other places should start asking themselves a very uncomfortable question. Are we next? Pause. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who get these updates first and click subscribe. So let me explain why this story could hit far beyond California. After the Supreme Court's Bruen decision, states were told they could not make ordinary, law-abiding people prove some special reason just to carry for self-defense. That was supposed to shut down the old May issue style of gatekeeping, where a regular person could be denied because some official decided their need was not good enough. But what happened in some places after Bruen? The rules changed on paper, yet the process stayed brutal in practice. Fees stayed high, training lists got longer, interviews piled up, agencies got flooded with applications, yes, but some also seemed perfectly happy letting those applications sit. So the battle shifted. Instead of arguing only about who can apply, people started asking how long government can make you wait before the right is effectively gone. New York City is a good example of why people are so fired up about this. A fresh lawsuit there says some applicants were waiting 22 months for a concealed carry permit, even though state law points to a 6-month timeline. Think about the message that sends. The Supreme Court says you have the right. State law says the process should move in months. But in the real world, the applicant is still stuck for almost 2 years. That gap between what the law says and what the agency does is where the next big fight is happening. Now, this is where the DOJ and states back it part needs to be understood the right way. The immediate permit delay case in Los Angeles is being pushed by private plaintiffs and now by the DOJ's own lawsuit. But the larger movement against backdoor carry restrictions is also getting support from the federal government and from coalitions of states in other major Second Amendment cases. The DOJ has filed briefs supporting gun owners in major carry-related fights, including a Supreme Court case out of Hawaii over restrictions on where permit holders can carry. And over the last few years, groups of more than 24 states have repeatedly filed briefs backing broader carry rights in big court battles. So even when the facts differ from case to case, the message coming from those filings is similar. A right cannot be respected in theory and blocked in practice. Here's what most people get wrong about this moment. They hear one big title and assume all permits are about to disappear. No, that is not what the courts have said. Bruen did not ban all permit systems. Courts have not ordered every state to go permitless. And this Los Angeles ruling did not hand out permits overnight. What it did do is reinforce a very important idea. If a state chooses to require a permit, it cannot turn that permit process into a slow-motion denial machine. That is the key takeaway for you. If your state has a permit system, the fight is no longer just about whether the form exists. The fight is about whether the process is fair, timely, and tied to clear rules instead of endless delay. If your local office is moving normally, great. If not, agencies around the country may soon face much more pressure to explain themselves. Laws change fast. Court rulings move fast. Agency behavior can shift fast too. Subscribe now, because the next video will break down exactly what records you should keep if your permit application starts disappearing into a black hole. So here's the bottom line. A federal judge just kept a major permit delay lawsuit alive. The DOJ has already sued over what it says are unconstitutional carry permit delays, and new cases in other places show this problem is not isolated. That should tell you one thing very clearly. Delay is becoming the next front line in the gun rights fight. If you apply for a permit, do not just file and forget. Know your state's timeline. Save every document. Track every contact. And if the process drags far past the law, do not assume that is normal just because the agency says it is. Pause. And if you want clear updates without the legal word games, subscribe right now. I do the research so you do not get blindsided. This channel is here to help you stay informed, stay careful, and stay on the right side of the law. Final simple disclaimer. This video is for education only. It is not legal advice, and laws can change fast depending on your state, your city, and the next court order.